usually do this on my own time, but I am going through my YouTube comments right now, and it was a comment on a post that I had made the other day about Workday's AI discrimination case that's going on. I'm gonna read the comment to you. I'm gonna show it on the screen. This is no dig at the commenter, because the reason why I do this is because a lot of people don't understand employment law and how much control and rights that they actually have. So I just wanted to discuss that with you guys. So the commenter says, talk about a waste of time and court resources. There is absolutely zero way for them to prove that's why. My first question is their resume formatted and written to even be able to be read by the software? Workday is not the one doing the hiring. They are screening resumes to send to clients. That's it. If he was not chosen, it's because, I'm assuming he meant his resume, did not fit what they are looking for. He was denied in 2 minutes or less. And I get the assumption in this, especially if you aren't readily familiar with the legal system as well as employment law. However, I would pump my brakes on the zero way to prove it, simply because if courts have actually allowed discrimination cases involving AI to move forward, they're using statistical patterns. Right? So if a system is consistently filtering out a protected class, which it appears this man is based on his disability, or plural, because I think he mentioned two, being a cancer survivor as well as having asthma, then that's admissible evidence. So it's not a zero way to prove it. It's not easily winnable, I will say that, especially when you are going up against the system of AI, and because our government has decided not to really regulate it in any way right now. So this case would symbolize some type of regulation. When we're talking about resume formatting, it matters, it does, but it cuts both ways, because the software itself is designed in a way that disadvantages certain groups. Well, if it is, we don't know that it is. This is what they're trying to prove. So if it is, then that's really the whole point of the lawsuit. Now, put a pin in that, because that brings us into disparate impact, which our current administration is trying to say does not exist. They're basically saying that, we shouldn't have to prove anybody keeping out a protected class of people, whether it be their race, disability, their age, their gender, whatever, right? So if it is actually designed that way and it disadvantages those groups, then that's literally the point. That's the point of this lawsuit. So it's not a frivolous lawsuit, essentially. Keep in mind, there's no AI governance right now, right? We're holding on to that thought. Okay. So Workday is, of course, yes, a third-party screener, right? That doesn't get them off the hook because it's their equipment, right? If a tool that you're providing is discriminatory and is producing discriminatory outcomes for your clients, then you carry liability for that. It's something that you created. It's basically doing the discrimination, not your clients. It's still discriminating, beloved. It sounds like you want to argue for the plaintiff, which is fine if that's what you want to do. I want you guys to stop complying in advance. So we know that AI is here. We know that AI is not going anywhere, all of that. And that's cool. But it needs governance. And we just shouldn't accept things at face value just because that's what's giving to us. All right? So I hope that helps. And you probably need to follow this page. Bye.